Okay, Abusia, I have former Chief Justice Atuguba. Waba Edin Sembi Ababetuja about the removal of a former Chief Justice Torkonoo. Na mamene de or Chini Muko a sroba from Crana. Ya na ye nedi, ene ye di kan ye de bremo say a former Chief Justice Torkonoo. Sisi and was answer ko file for application or kwa challenge for ne removal no. Ene Chief Justice Atuguba, former Chief Justice Atuguba, ono ankasa ba ede ensem bi aba betudwa saa ne ensem ode betudwa no yem break no amom yenko na yenkonko tie ensem a Atuguba ede etudwa unsubscribe ya subscribe like na share ma afofron so ensa intumi enka bi aha Ghana Politics Avenue so madam ase.
That's a JIPC CEO there. Now, a number of issues that the former Chief Justice and now member of the Council of State, Sophia Akuffo, raised as well, generated some reactions as well from you. Earlier this evening, my colleague Beatrice Addo sat with the former or retired Justice of the Supreme Court, William Atuguba, who also had his thoughts to share about the removal of the Chief Justice, Gertrude Araba Esaba Torkonoo. And this is what he has been saying to us. That's Beatrice Addo earlier this evening regarding the matter of stated misbehavior, which was the grounds on which the Chief Justice was removed exactly a week ago after that 5-member committee established to hear the petitions against the Chief Justice did their work over the period, and it was just on the basis of one of 3 petitions, that enforced petition, that stated misbehavior was established. And this is what William Atuguba, the retired Justice of the Supreme Court, has been saying. Take a look.
In the first place, these procedures were supposed to be in camera, so ask me whether I've followed or how could I follow, except they leaked out by chance. They were supposed to be in camera, you know. But what came out in the public domain satisfied the constitutional requirements. Petition is received by the President. If it's not frivolous and vexatious, because Ajechum and the Attorney General House decided if the petition is patently frivolous, the President needn't even forward it. But if it is not, then he consults the Council of State. They find that is Ajechum which introduced prima facie also in relation to it. If it is found, then a committee is set up in accordance with the provisions. The committee goes in, they hear the matter fairly and thoroughly. And then the recommendations, well, I think that was done.
So the process was fair?
Oh, yes, I know.
But the dismissed CJ doesn't think so.
Do you expect her to think so?
She during a press conference, complained about being denied the presence of her family, searches and what she called mental torture, even in a supplementary affidavit. I'll just read a bit of that to you. She said, a complete desecration of my basic constitutional right to a fair trial, violation of my dignity and subjection to inhuman and degrading treatment, a kind not meted out even to accused persons on trial for treason and other offenses against the state. She went on at that press conference to talk about the Addo Lodge, which was used as a place of hearings, and a reminder of how her uncle was murdered, as if to cower her into intimidation and all of that.
But I saw on social media a video when I think that place was refurbished very heavily, and the then president praised its quality and everything. So I don't know. Now I say that if in a certain court, let's say it was being tried, or this investigation was in open court, and a member of the family shouldn't be used. I don't know. I really don't know.
So you disagree with her description of the process?
Oh, sure. I mean, these things are neither here nor there. In the long run, it is the substance of the matter that matters. The substance of the matter. Was she given a fair hearing?
She said she wasn't.
Oh, what? I don't know. This was in camera. How did she say she was not given a fair hearing? Because of what I said, bodily searches, and her family shouldn't be there. If the thing is to be, the Constitution says 146(5) plus 5, all proceedings under this article shall be held in camera, and the justice or chairman against whom the petition is made is entitled to be heard in his defense by himself or by a lawyer or other expert of his choice. So if it's in camera, has a provision for, allowing your relatives in?
See, the point is clear about what Kofi Bento takes a path that he's not justifying what has happened. There's wrong that has been done. How the wrong is to be remedied, or who should carry the burden of that wrong, is one question that he raises as to, yes, even if it was the request of the former Chief Justice to have been paid a certain amount, who was to dispense that amount, even if it was captured in a particular policy, one. And secondly, the fact that this penal consequence is too grave to warrant, really, this particular sacking that we have seen. I want to find out from you if this sacking is a consequence that matches the offense that has been established of stated misbehavior in this instance.
Thank you. I think the law is the law. And when it comes to sanctions, the law does not thrive on an assumption that it should be commensurate with the offense. Sometimes, thresholds are set, sometimes not. So it depends on the status and gravity, of the offense. In this case, I would say that for somebody who has worked for about 21 years, giving dedicated service to the nation, it will seem at first sight, to be too punitive, to lose everything. A way could have been found. We could have circumvented and, say that, well, ultimately she must be removed. But looking at the surrounding circumstances and the 337,000 and all that, and the fact that the president is the father of the nation, something, could have been done, and say that, well, rather than go home persualess, we would retire you. You can, enjoy all your benefits, including your retiring benefit. That could have been one way out, or, well, you've done it, we'll sanction you, but at the same time, will allow, the constitutional provisions to be implemented in your favor. So that's my immediate reaction. Having said that, this whole Torkonoo CJ removal process, I would say that the former Chief Justice, Torkonoo, was a victim of many circumstances. A victim of many circumstances. I can outline, say, 5. The first, was the president's meeting with the lawyers, the NDC lawyers, and expressing a view. Initially, my take on the president's meeting, then the NDC's presidential candidates meeting with the NDC lawyers, was that yes, I mean every presidential aspirant, will say this or that, and as Martin Pebu said, they can make political U-turns. Nobody will worry himself or herself about that. So that's the first. The second, the absence of any definition in the Constitution on what will amount to stated misbehavior. Because the framers of the Constitution thought it desirable to outline, certain everyday, words and to assign meanings in the Constitution, Article 295. But with regard to stated misbehavior, the framers, didn't say anything and let it ajar so that it will depend upon interpretation, and judges, are also, ordinary mortals. When you give them the chance to interpret. So you see in the Franke Jechum, and AGN Bright Akwete case that, the retired Chief Justice, Professor Dateba, went to lengths. But still, if you read, the judgment, and, luckily, Pebu, has walked us through pages 766 and 767 and all that. You see that even after outlining examples, our respected, Justice Dateba still left it open, meaning that the categories are not yet closed. So day in, day out, other, things could come in which will qualify as stated misbehavior. So that's the second, the absence of any, definition to guide the court. The third, self-induced, was the nomination and subsequent appointment of Torkonoo, out of 10 by the former president, which, was severely criticized, but the former president, didn't heed, any call to take a second look at that. For me, that was a catalyst,
There were other senior persons.
Sure.
Than her.
Taken out of 10. Then the fourth circumstance of accident, the fetish that we are making of our precedents. So the Franke Jechum stood guard over any remedial measure, favorable measure, for Torkonoo. Stood guard because the Franke Jechum thing has interpreted Article 146 holistically in accordance with the canons of interpretation, that in interpreting or construing a provision in the statute, you do so, so as to make a consistent meaning by looking at the entire. So you don't merely look at Article 146, 6 to 11 in relation to the removal of the Chief Justice, but you also go backward to Article 146, Clause 1, which will provide guidance on stated misbehavior. This is, what has caught up, with this whole saga of total loss. If in Franke Jechum, the Supreme Court, had said, look, we notice first and foremost that a Chief Justice can only be a Chief Justice, if he has served a certain number and being appointed from among, the justices of the Supreme Court. The question is, what if the Chief Justice is not coming from the bench? Would Article 146.1 apply to such a person? Because the person, wouldn't in the first place have been a justice of the Superior Court upon elevation, to the high office of, Chief Justice. So the Supreme Court in Franke Jechum, I think missed the point when they put the two together and said, by parity of reasoning, since, you can only be a Chief Justice, if you are a Justice of the Superior Court, and therefore whatever affects, your position or status of Chief Justice you
Should
know,
also apply.
must relate back to your status as a justice of the Supreme Court. This is where the harm is. You know, it's a misconception because Article 146, Clause 9 refers to in each case. So the Supreme Court should have segregated that you may be a justice of, you know, the Supreme Court. If we are looking at your exercise as a CJ, yes, Article 1461 says stated misbehavior, you know, of a justice of the Supreme Court. Therefore, we would, you know, divide into two, limit ourselves to justices of the Supreme Court, and then limit ourselves to the CJ who is being removed. If they had, you know, told that line, we wouldn't have a situation where, you know, it relates back
to the instance.
when the Constitution says there shall be no retroactive legislation, but you are interpreting a provision of the Constitution retroactively. I don't think, you know, their lordships were right, you know, insofar as they did that. And that is, you know, what has affected former Chief Justice Torkonoo. Then the fifth, self-induced. Why ask a daughter to be a contractor in respect of some services in your office? She brought it, you know, upon
decorating
herself.
an office.
Yes, she brought it upon
and the
herself.
furniture and all of that.
Yes. The other one, my good friend Kofi Bento, you know, was struggling, you know, to align. You see, it is an audit issue, yes. But who is the head of the judiciary? The Chief Justice. Article 125, Clause 4 is clear. The Chief Justice shall be the head. So the buck stops on the desk. So whether an accountant or the auditor or whatever, any person, it is the Chief Justice. And she could not claim ignorance that being the head, the buck stops on the desk. Being the head, the buck stops on the desk. So trying to claim ignorance that, well, you know, as my good friend will put the meeting baby, and now they are there no buy, and I mean, so me sign. I mean, it will lie in the mouth, you know, to say so. So she must have known, you know, the consequences, you know, of signing. But after all, who approves and who disapproves? This is the Chief Justice. But the most serious of the, you know, stated misbehavior, from my point of view, was the attempt on her part to use a certain provision of the Civil Service Act to recommend the appointment of, you know, some 5 persons as justices. That constituted judicial misconduct.
So that's more, it's serious, more than the misappropriation of this.
Judicial misconduct. See, if you look at the Judicial Service Act 2020, Act 1057, as chairperson of the Judicial Council, she has the following powers. I'm reading Section 7. That's stated misbehavior.
It is.
Stated misbehavior. So, members of the service and vacancy. Where there is a vacancy, that's Section 7, I'm quoting. Where there's a vacancy, A, under paragraph H, under paragraph B of subsection 3, or subsection 4, or subsection 2, of section 9, or B, as a result of a declaration under subsection 6, or C, by reason of the death of a member, the Chief Justice shall notify the President of the vacancy, and the President shall, in respect of a person who is appointed by the President under paragraph N of section 5, appoint a person to fill the vacancy. unquote. She was trying to lift this particular provision, and under this, wrote a letter to the president, listing 5 persons. And when I looked at it, and Article 144, I felt, it amounted to judicial dishonesty. And for that, I was on air, that, she should be reprimanded. And on one of your shows, I did say that it could cost her her job for trying to be deceitful. For me, I mean, that could have, and Kwekwaza, read into it and quickly.
That's what's coming to, because this particular one was captured in Professor Stephen Kwekwaza's petition, which was thrown out by the former president, Nana Addo Akuffo, that it didn't constitute any grounds whatsoever for any misconduct. But this same concern has found favor in the sight of another
it's very
committee.
Serious, very serious. It meant that she was trying to procure the elevation of those 5 justices by fraud. And fraud vitiates everything. As a Chief Justice, she had, subscribed to the oath, to act in accordance with the Constitution. Why try to use, a provision not in the Constitution as a basis for appointment of, persons to the Supreme Court? I mean, if there was any stated misbehavior, I would just rely on that and say that, that was sufficient. I will not bother. But because, Kofi says that the 337 or this thing, I want to, tell Kofi, you see, if you admit to some infraction, and so by which they say, refund it, the high office of Chief Justice, it is not kitikiti. And the Martin, refers to our good friend, Yes Antoine. Former Chief Justice Sophia Akuffo would always, usefully remind everyone, especially, law students going to take their entrance exam, that when you take the exam and the pass mark is 50, and you had 49, 0.9, now kase ka kitikiti nkaminya 50, and kitikiti in law doesn't exist. You either had a 50 or you didn't have a 50. So there's nothing like a kitikiti. Therefore, 337,000 will sound kitikiti and grating to the ear of, civic-minded, person. But the law is the law. Whether it is kitikiti or did she do what was in consonance with the Constitution? No. So she had contravened the Constitution. She had contravened the provisions of the Judicial Service Act. And she wears 2 hats, the hat of the judiciary and the hat of the judicial service. And both she contravened. So for me, I mean, it was, the committee was right. But we could also deal with the issue of retiring benefits, with some human face. Is it, equitable that she should go home persualess? Does the president have the power? And the president has, gargantuan powers under Article 72 of the Constitution going to the clemency. So, I mean, the president has all that. Where I will fault the president is that he acted too swiftly when the report was submitted and he received it. As, our sages will put it, he could have, taken it home to sleep over it and obtain some advice from his pillow. I'm quite sure that, something better than what has happened could have come out of that. But not too long after, receiving the report, You know, that is where I think, as father of the nation, he can take a second look at the decision.
But could he, because the specific dictates of the Constitution, Article 1469 specifically prescribes the action of the president after receipt of the report of the committee. He is bound to act. Could he have done any differently?
You see, that's why I said fetish.
Okay, I was winning and some course so our political highway so a year former Chief Justice a year Atuguba and I attend in Cassa or this and seminal to jar a day am I but I must say some J penny cocotiza and some way at my Ghana Politics Avenue so and don't forget to click on the notification bell send any updates be a drop piano on so on sa a bit to me aka madam.